In the complex litigation system, disputes over electronic evidence are considered especially heinous. These disputes are resolved by two separate yet equally important groups: the technologists who investigate the data and the attorneys who argue the merits in court. In electronic discovery, the dedicated consultants who analyze and investigate the data are an elite team known as the project advisors. These are their stories.
Episode 3 of our Law and Order Discovery Dispute Unit. If you've watched before, you know the format. We basically have a kind of a fun little litigation with a judge who decides, and based on current e-discovery case law, we base our fact pattern on that. And our episode 3 is called A Hard Pill to Swallow. And I'll show you the facts in a minute. I'd like to introduce our participants today. Angela Shapiro is a shareholder at Butzel Long. She's got extensive experience in commercial litigation, and she has a very strong focus on e-discovery. She's also a SEDS specialist and an information privacy professional, and she sits on her firm's technology and pro bono committees. Gretchen Moore, who is a shareholder from Strasburger, McKenna, Gutnick, and Gefsky, focuses on commercial and civil litigation and also has vast e-discovery experience. She is also SEDS certified, and she chairs the e-discovery committee at her firm and is co-chair of the litigation practice group. I myself am a senior project advisor here at Acorn, and I have a long history of various areas of e-discovery related work. And Jeff Hudson, who is our judge today, is our director of professional services. He's an experienced complex litigation attorney, e-discovery project manager, and a technology leader who excels in developing and implementing, all practicable and manageable solutions for clients. And so we're really excited to have everybody here today. I think this should be fun. And so I will move to the facts next. Defendant, or plaintiff in this case, is Wiley Life and Casualty. They're a national health insurance provider, and the defendant is Lockhart Value Mart, which is a grocery store chain that has pharmacies inside their store locations. At one point, they had a price matching policy at the pharmacies where they sort of did a competitor price match that would allow customers to pay cash to receive the lowest advertised price. Wiley Life obviously insures some of the people who used that pharmacy and took advantage of that price matching. In June of 2016, the person running for Attorney General indicated that he was going to investigate this price matching policy for fraud and reimbursement. And that was about mid-June of 2016. As a result of that, Wiley filed a lawsuit alleging fraud and reimbursement prices submitted by Lockhart in August of 2016. Lockhart initiated a litigation hold on August 15th of 2016. But at issue in this case today is basically on June 12th, just around when the potential investigation by the Attorney General was filed, one of the regional managers, Patty Holmes at Lockhart Value Mart, sent an email to 75 of her stores instructing people to throw away signs, and any documents that related to price matching. And so her 75 stores complied. She also advised managers verbally on August 25th, 2016, not to mention that she had told them to delete anything, and followed that up with an email reiterating the exact same message on August 29th. The defendants did not produce that email until the close of depositions. And as a result, our plaintiff is seeking sanctions for failure to issue a timely litigation hold, intentional destruction of material evidence, and efforts to conceal and obstruct discovery of the spoliation of that evidence. The defendants maintain they did issue a timely hold, they did not intentionally destroy evidence, and they did not attempt to conceal any discovery of alleged spoliation. And so for today, our issues are essentially these. Did the defendants fail to issue a timely litigation hold? Did they intentionally destroy evidence? And did they attempt to conceal discovery of any allegation of spoliation of evidence. And with that, I'm going to turn this over to the judge, Jeff Hudson, and I will stop sharing my screen so you guys can get started.
Great. Thank you for the introduction. Ms. Shapiro, I believe this is your motion, so we will start with you. You have about 5 minutes.
Angela, you're on mute, sorry.
Figures, I just made the best argument of my life. Good afternoon, Your Honor. Angela Emerling Shapiro from Butzel Long for Plaintiff, Wiley Life and Casualty. Your Honor, we are here today to address Lockhart Value Mart's failure to preserve and intentional destruction of data that goes to the heart of this lawsuit. Starting in 2010, defendants implemented a special pricing program charging customers a lower amount based on price lists it developed and maintained electronically. Defendant did not use those same prices when passing along reimbursement requests to insurance companies, including the plaintiff in this matter, and that is the heart of this matter. In early June of 2016, 6 years after the pricing program was implemented and 6 years into its process, there was extensive press coverage about a potential governmental investigation into defendants' practices. A candidate for state attorney general was asserting fraud with regard to reimbursement requests made to the government. 3 weeks later, also in June of 2016, plaintiffs sent a letter to defendant also alleging fraud based on the same actions over the prior 6 years. Again, in June of 2016, 6 years into a heavily advertised price match program, one of defendant's managers suddenly emailed 75 pharmacies and instructed them to, quote, throw away all price matching lists and get rid of all signs that say we match prices. No similar requests had been made during the prior 6 years. Instead, it was clearly prompted by the company's understanding that it was headed for a lawsuit. So we now have custodians of key evidence being told to embark on a course of data destruction. Defendant then allowed its employees, not days, not weeks, but 2 months to act on its manager's instructions. No litigation hold was issued by the company until August 15, 2016, more than 2 months after it was crystal clear that at least one lawsuit and possibly a governmental investigation was headed its way. 10 days later, on August 25, the same manager who sent the instructions back in June to destroy price matching data met with store managers and stated, I need you to understand that I never told you to delete anything related to price matching. 4 days after that meeting, the same manager sent another email again stating, remember what I said about you never being told by me to get rid of any price matching stuff. Of note, defendants held that email back from discovery until the 11th hour, after depositions were complete, producing it only after the meeting was disclosed during depositions, and one of the managers in attendance testified that we provided all the documents we had after we got the request, the litigation hold, but there weren't many left. Your Honor, there's case law cited in our briefing, but really the guideline here is Rule 37E. It provides a solid roadmap for exactly this type of situation, where electronically stored information should have been preserved in the anticipation of litigation, but was not because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced, then the court has 2 sets of options available to it to address or sanction that behavior. Here, we certainly have lost data. That's undisputed. The data is gone. We have testimony from at least one manager to that exact effect. It's gone. It's not there anymore. It wasn't there by the time the late litigation hold was issued. It can't be restored or replaced. We've had no suggestion through discovery that the same information that resided in the pharmacies, the price list that they developed based on their local competitors' pricing can be replaced, that it was backed up centrally, that it was emailed. There's nothing to suggest that it can be replaced. It is gone. So at that point, we turn to 37E1. Upon a finding of prejudice to another party from loss of the information, the court may order measures no greater than necessary to cure that prejudice. Here, prejudice is clear not only from the fact that this is central evidence to the very core of this lawsuit, and it is gone. But also prejudice is something that, if you look at the commentary, the 2015 amendment commentary to Rule 37E, is something that in situations like this, where we're being asked to prove what was destroyed, or prove the importance of something that was destroyed, that burden can be shifted to, in this case, the defendant, as should happen in this case. But even without that burden shifting, knowing that defendant cannot show that this evidence was not critical, not important, not relevant to plaintiff's case, it is that burden is already met, with or without the burden shifting. There's no question that the requirement that the party to be sanctioned failed to take reasonable measures is satisfied here. Not only did the litigation hold letter go out 2 months after it should have gone out, but it was also following deliberate and affirmative steps to destroy data and to allow additional time for that course of conduct to play out. When you're looking at the sanctions or the remedial measures available under Rule 37E1, what we've just discussed, those are the only preliminary factors that have to be met. Intent is not important. So there are remedial sanctions available here that should be imposed, even if the court does not find that the actions of defendant in destroying the materials that it did at the instruction of its manager during the 2 months between when it was clear that litigation was forthcoming and the time that a litigation hold was actually issued, then there are still remedial measures that can and should be implemented. And those are addressed in the rules, so I won't go through them. I know we're running low on time already. They do include, though, introducing evidence or making arguments to the jury about the loss of the data, allowing additional discovery, or barring certain evidence from being introduced by the defendants at the time of trial. So that brings us to 37E2, where we're talking about spoliation with an intent to deprive. And while I very firmly believe that 37E1 is easily satisfied in this case, I also believe 37E2 is, because here we do have evidence of intent to deprive plaintiffs of the evidence at issue. It's very clear evidence. We have it black and white. We have it in emails, although those emails were withheld until the last minute and should not have been. We do have that. So with that, plaintiff asked this court to issue spoliation sanctions up to and including dismissal of this case. If the court has questions whether intent is met sufficient to satisfy the E2 level of sanctions, we ask for remedial sanctions under E1 and or additional spoliation discovery that would go to the intent question. Thank you, Your Honor.
Thank you. Ms. Moore, we will now hear from you.
Thank you, Your Honor, and may it please the court. My name is Gretchen Moore, and I represent Lockhart, the defendant in this matter. We're a regional grocery store chain with 3,000 stores and over 7,500 employees who work exclusively in our pharmacy division. Your Honor, the facts of this particular motion do not support any sanctions against Lockhart. Let's start with the timeline. In early June of 2016, there were news stories about a state attorney general election and some interest in this particular topic. June 12th is the date that a sole rogue employee, mid-level manager of Lockhart, apparently sent an email to a minimal amount of stores related to getting rid of some documentation. At the end of June of 2016, Wiley, an insurance provider, sent a letter to Lockhart making some allegations related to price matching, which was vague at best. Wiley then filed their complaint on August 25th, 2016. General counsel for my client issued a litigation hold letter to all pharmacy manager employees and staff on August 15th, 2016, approximately 6 weeks after receiving the letter from Wiley and before litigation was even filed in this case, which is a perfectly acceptable time frame in which to order a litigation hold letter, a similar time frame, Your Honor, to the super value case, which I will direct the court's attention to. The allegations in this case, Your Honor, pertain to one mid-level manager of Lockhart, Miss Patty Holmes. Ms. Holmes is a regional manager in charge of 75 stores. To put this in perspective for you, we are 3,000 regional stores. Her reach only exceeds to 75 of the 3,000 regional stores that have pharmacies, which is less than 3% of all stores. There is no evidence in this record that any officers of Lockhart even knew about this, that any officers or directors, any Lockhart condoned it or asked her to do anything or gave any instruction. She apparently sent a single rogue email in early June, again, around the time of these news stories, Your Honor, before there's anything close to anticipation of litigation. The testimony and evidence elicited by the plaintiff in this motion is weak at best. Even if this one rogue employee sent the email and then made the statement to 3 managers about not stating it, I'd ask Your Honor to look at the record to see evidence of what was actually destroyed, whether any information really is lost or irreparably lost, if that. And what are the motives behind Ms. Holmes' June 12th email? Frankly, my company is in the process of phasing out this particular price match program anyway. Her motivations could have been in perfectly good faith. There's no evidence to suggest otherwise. As you know, in this particular jurisdiction, Your Honor, because we don't have any cases directly on point, you can glean authority from other jurisdictions on this matter who have issued opinions since the federal rules were amended in 2016. And as my opposing counsel has set forth in detail, 30 is the appropriate rule here to look at to guide your analysis. Your Honor, under Rule 3070, which was extensively changed in the 2016 rules, we have a series of questions that Your Honor must consider before we even get to the sessions question. Byposts is what I call them. First, is there information that should have been preserved? Second, is there data lost because of a failure to take reasonable steps to preserve evidence? And finally, what that evidence that was destroyed, if it was, can be restored or replaced through additional discovery. So it's a very fact-specific inquiry, and let's just look at the facts of this case under that inquiry. When did Lockhart preserve? When was litigation pending or reasonably foreseeable? The litigation is an incredibly fact-based inquiry. The defendant has to determine whether there's a real credible threat of litigation. You're familiar with the Sedona Conference, Your Honor. They have clearly stated that rumors alone are not enough. News stories circulating in early June of 2016 are not kind of triggers that would require my client to issue a litigation hold at that particular point. Clearly, when they did issue the litigation, it was a perfectly reasonable circumstances in terms of, they received a letter in June. At the time, they felt litigation was actually pending 10 days in advance of actual litigation. They sent the litigation hold. They circulated it appropriately. They updated it. They held training sessions and sent reminders. In the super value case, Your Honor, that you're familiar with, there was an actual government subpoena that was issued. And after that government subpoena issued, approximately 5 weeks later, the entity issued a litigation hold letter to its pharmacy managers. And then about 7 weeks later, the entity issued a litigation hold letter against its corporate marketing folks. And in that case, the court found that the timing was perfectly appropriate. Again, Your Honor, that was a subpoena that was issued to a company as opposed to some news stories and a vague letter that was sent to the. Regardless, at the time Ms. Holmes' email was sent on June 12th, that was during a time, again, that rumors were circulating at best, and no amount of due diligence would have called counsel to send a litigation hold letter prior to that date, certainly. The second question, Your Honor, is data lost because of the failure to take reasonable steps to preserve? Under the circumstances, there were reasonable steps to preserve evidence. Most importantly, plaintiff's declaration and deposition testimony is inconclusive and uneven at best. We had witnesses say, and I'll just read from the record, one witness said there were never any documents destroyed relating to the price match program. One witness said, I remember litigation whole email, we fully complied. I don't recall any instruction document before or after that time. Another witness said we provided all the documents we had after we got the request, but there weren't many. And yet another witness said we discontinued the price matching at my store because we were tired of answering questions about it from corporate. Any damage, Your Honor, that could have been done by this instruction by Ms. Holmes, which had a reach of 75 stores. And I will note, there is no actual evidence of documents being lost or documents being properly damaged. That could have been is outweighed her reach to such a small amount of stores. And this particular price match program was instituted in every store in defendant's company. Simply put, I haven't seen any actual evidence of loss and never really lost. And that is the third question, Your Honor, the third guidepost in Rule 37, which is, can it be restored or replaced through original discovery? Again, it is plaintiff's burden to do the forensic analysis. What you've lost that you can't replace. Unlike the Leroy case, which Your Honor is also familiar with, there's no evidence here of mass deletion of email, no complete spoliation of source code like we saw in the Leroy case. Particular to be found was staggering. That's just not the case here. So Your Honor, needs to be issued in E1 and E2 related to prejudice or intent to deprive, because I don't think we get past the first three guideposts in Rule 37. But in any event, Wiley has not demonstrated that they are prejudiced. They have not demonstrated that Ms. Holmes acted with an intent to deprive. Your Honor, sanctions are not warranted here again, Lockhart, as the timely issued litigation letter. They did not intentionally destroy evidence or obstruct discovery or spoliate evidence. I would respectfully ask Your Honor to deny the motion for sanctions in this case. Thank you.
All right, thank you very much. Thank you both for your arguments here. I will make my ruling now. Regarding the first issue that we had here regarding the timeliness of the litigation hold, while I don't know that it was necessarily ideal, the timing, I do feel that it was likely appropriate as far as the timing as related to knowledge of potential litigation and actual litigation. So I'm not going to penalize the defendants for the timing of their litigation hold. Regarding the second issue of the defendants destroying material evidence, I do believe that there was certainly the loss and destruction of relevant and responsive data at the direction of Ms. Holmes. I think that we are yet to determine if that is unrecoverable and prejudicial to the plaintiffs in this case. In the event that that is determined through further testimony, or we're unable to reconcile that through additional discovery, which I'm going to limit to the next 15 days, then I will consider an adverse jury instruction accordingly related to that data, that it may be deemed in a negative light towards the defendants if we cannot determine that it is recoverable or replaceable in some other way. As far as attempts to conceal or obstruct discovery, I do not believe that gives rise to spoliation. Again, had Ms. Holmes been an officer at this company, someone in the general counsel's office, are something of a higher ranking official than a regional manager, I think that we might have a different outcome here. But based on what I've seen from the record, and it appearing that she be the only one that that did direct the destruction of data, I don't think that this gives rise to spoliation. So I don't think that any of the charges or allegations here give rise to, certainly to a dismissal on basis of destruction and spoliation of evidence. I do think that an adverse jury instruction may be in order if the issue regarding the destroyed materials is not resolved in either in short order through additional discovery request or through some type of remedial testimony as we move forward. And I will enter an order accordingly. So, thank you.
Thank you, Your Honor.
All right, and with that, we did want to take a brief look at a couple of the cases, current or recent cases that we used somewhat as a guideline to set our facts and come up with our arguments. Both of these were mentioned during the arguments by counsel. I'll cover the super value case really quickly. It was a case where the facts were fairly similar to the fact pattern that we argued today. However, there was a government investigation that had begun, subpoenas had been issued, and then there were some destruction of some price matching documentation. There were also some questions as to the timeliness of litigation holds. In that case, the judge ultimately ruled that the actions of the defendant did not give rise to a level to impose sanctions, regardless of how egregious some of the conduct may have been, at least not based upon the evidence that as it had been presented to date. And then we also have WeRide. I think Amanda is going to give us a little bit more about that case and its implication of a post legal hold intentional destruction.
Yeah, WeRide is based out of the Northern District of California. And this one basically went the exact opposite of super value, where the judge issued terminating sanctions, had to pay costs. It was a trade secret case where they alleged stealing source code, disparagement to competitors, soliciting employees, and taking data. And WeRide filed suit and got a preliminary injunction against them from moving forward. And during the pendency of the preliminary injunction and the case, they destroyed emails, they didn't produce or spoliated source code, they wiped computers, and they used an ephemeral messaging app to discuss things, and then that auto-deleted. And the judge found that it was just so egregious that he ordered them to pay costs for discovery. Like, it was just, yeah. And you don't really see that very often from the case law, that the spoliation happens so extensively, and that the courts award, courts almost never give sanctions that harsh. So
I would also state that one of the interesting things about the WeRide case is that the defendants actually admitted to all of it on the record. So yeah.
But yeah, so those are some pretty recent case law that we found. And now's kind of the time where we get into questions and answers and what, if anybody's had experience with this, and what's that been like? How has it been to argue those things in actual court? I'm sure you both have experience on this.
Sure. So I can tell you that I do have experience on both sides of this issue. And since the 2015 amendments, most of the cases come out kind of on a middle ground for me. There usually are, there's typically, if it's important enough that it's being raised, there will likely be some form of remedial discovery or other remedial actions that are involved to get to the court to the point where it's comfortable making a decision or on whether or not more intrusive sanctions are allowed for. I can say on the cases that were referenced here today, so super value is not particularly helpful to me because there's not a lot of analysis there. It's an interesting fact pattern, and I appreciate that being brought into play here. The We Ride case was really more, in my opinion, the harsh sanctions were justified, yes, by 37E, but more so by 37B because they were doing a lot of this bad behavior while there was an explicit order not to do any such thing. So both of those cases are interesting, but I would suggest looking at your own jurisdiction's recent case law on 37E, and you will find, I'm almost certain in most jurisdictions, certainly in the Sixth Circuit here, several cases that just line for line go through and tell you what the analysis is and what the courts are looking at.
Yeah, I agree in terms of the We Ride case. The 37B aspect of it was quite egregious because there were actual orders that were being violated. The destruction overall in that case is quite egregious, so it's worth reading the fact patterns. In the Third Circuit, we also have a case that is certainly more egregious than I think this super value case on the fact patterns here, the GN Netcom case, where you had more higher level, higher ranking officials making statements and doing more to destroy and permanently destroy data. And then it was determined through forensic analysis that it couldn't be recovered. They spent a lot of time and money litigating ESI spoliation. But in the end, they also, there were some significant sanctions issued in part. So yeah, look to your jurisdiction. Certainly look at the egregious ones, but the ones that aren't as egregious, you still have to be careful of because you expose yourself to and your client to all kinds of trouble that you don't want to get into when you get into these disputes. So.
Yeah, and I think that Gretchen, you made a really good point in your argument, which I thought was probably even with the lack of analysis in the actual super value opinion, was the rank of the employee who ordered the destruction. Had it been the GC, or had it been the head of sales, or had it been the CFO, someone along those lines, then I think you're looking at a much tighter decision in a situation like that, whereas you just have a regional manager doing it. And I think that's probably a reason that the court found the way that they did in that case, is that even though they obviously, there was obviously some data destruction, I don't know that it gave rise to the level of the defendant as a whole, as an entity itself, participating in the destruction of relevant or responsive data, and then trying to cover it up, as opposed to a single individual, and based on their role and responsibilities, probably didn't have the authority to actually execute much of either as far as it relates to their overall litigation and defense strategies.
Yeah. Although when I read it, I did think it was going to go the exact opposite way. So I thought the super value was interesting because I was like, that is not at all how I would rule. It's kind of like a punt till later kind of a decision from my perspective. But
well, I think it's also, I think a nod to, you really need to build your case too when you bring these motions. Really be able to point to the extent that you can, that's going to help you to point to some tangible issues in terms of actual destruction and loss. And I just feel like in super value, they didn't really have a lot of that. They had, uneven evidence in terms of what was even missing.
Right. Okay, well, we've gone a little over. So if anybody has any questions, we're still happy to take them. If we want to stick around, or otherwise, I wanted to give you a preview of next month. Our episode 4 is going to be social media distancing, and it's around discoverability of social media. So if that's of interest to you, that will be July 9th and at 1 p.m. Central, kind of our default time. So yeah, if you guys would like to join, or if anybody else would like to contribute or ask any questions, or now's the time. Otherwise, we can wrap it up.
I would also like to take the moment to Gretchen and Angela, thank you again for agreeing to participate. We had a lot of fun.
Yeah.
Thank you. It was fun.
Okay, well, I'm not seeing any questions. Luke, if there are any, let me know, but I don't think so. So I would also thank you guys for participating, and appreciate everybody who attended. We hope that this is a sort of a fun intro way to learn about and argue e-discovery issues. So yeah, we appreciate everyone's time, and we'll see you next month. Tune in, I hope.
Thank you.
Thank you.
Bye.